Okay, well, good afternoon, friends of Maurer Law School, near and far. Welcome to our webinar on the big Supreme Court decision that was handed down last Thursday in West Virginia versus EPA. I'm Rob Fischman. I teach many of the environmental law classes here at Maurer, and I'm joined today by two of my colleagues. We've got Nicholas Almendares and Dan Cole, both of whom are my fellow law professors, both of whom are steeped in political science and management of common pool resources. I'm going to say a few words by way of introduction and then hand it over to Professor Cole, who is our resident expert on the Clean Air Act, who will give us a little bit of background on the statute that provides both the authority to EPA and, as a result of this decision, some limitations on what the EPA can do to regulate emissions of air pollutants that contribute to global warming and climate destability. Then we'll turn things over to Professor Almendares, who will talk about the significance of this opinion, particularly its announcement of the major questions doctrine and what that might mean for the regulatory state and limitations on the ability of Congress to provide to agencies broad authority to regulate new problems that are generated by new technology. I will say that, unfortunately, our colleague Sonia Carley from the O'Neill School of Public and Environmental Affairs is unable to join us this morning to talk about energy policy, but Professor Cole has generously agreed to say a few words on where we might go from here. Well, what do I mean by here? What I mean is on Thursday, with West Virginia versus EPA, the Supreme Court essentially slayed a phantom. It held illegal a rule limiting the emissions of carbon dioxide from power plants that did not exist. So that doesn't sound like a very consequential decision, but it is consequential, and we kind of knew it would be. I mean, unlike Dobbs, the abortion case from 2 weeks ago, we didn't have a leaked opinion to read. But the court had pretty clearly signaled that it would use this case and this old and never to be implemented rule as a vehicle to reach out and announce a kind of new activism in interpreting statutes and in limiting the power of agencies. For one thing, in 2016, when shortly after the Obama administration issued the Clean Power Plan, which was a rule that regulated the emissions of carbon dioxide, a greenhouse gas exacerbating pollutant, regulating emissions of that gas from power plants. In 2016, shortly after the Obama administration issued that rule, the Supreme Court essentially turned administrative law upside down and stayed the rule, basically suspended the rule until lower court could decide whether it was constitutional. That is more or less the opposite of what the Supreme Court had always done when challengers to a rule had asked that the rule be invalidated temporarily until a lower court had a chance to make a decision. A foundational principle of US administrative law had always been a kind of assumption of regularity, that agencies know what they're doing and are proceeding in a manner that's consistent with the relevant statutes, unless a court has examined the merits of the case and found otherwise. So our first clue was in 2016 when the court made this unprecedented suspension of the Obama administration Clean Power Plan. The Clean Power Plant rule was revoked by the Trump administration, which issued its own rule. And in 2021, a lower appellate court found that the Trump administration rule was illegal, that it was based on an impermissible interpretation of the Clean Air Act. And last fall, when the Supreme Court granted cert, that is, agreed to decide this case, agreed to decide the appeal of the district court decision, we knew that the Supreme Court was interested in reaching out. Why would it reach out to decide this case, which wasn't a live dispute anymore? Both the Biden administration, well, for two reasons. The Biden administration announced that it was not interested in reviving the Obama administration's rule, but maybe more important, the emissions reductions that the Clean Power Plan, the Obama administration rule, aimed to create, which was to cut the 2005 carbon dioxide emission levels by 32% by 2030. Well, by 2021, that aim had already been achieved. So there's just no reason anymore for the EPA to revive this old rule. So that was the signal that the court would use this case as a vehicle for narrowing the EPA's power, and it did. It found that that the normal rule, it found that the normal test for whether an agency regulation is legal under an authorizing statute, normal principle is that if the agency engages in a reasonable interpretation of ambiguous or broad text in a statute, then the court will uphold that. Instead, in this case, the Supreme Court announced a new rule finding that the Clean Power Plan presented a major question to the court. It was an unprecedented expansion of EPA power, and therefore it could not proceed absent a clear statement by Congress authorizing the agency to regulate in this particular manner. And the court last week held that the Clean Air Act does not provide that clear statement. So that's what the court did. I'm first going to talk, I'm going to invite Professor Cole to talk for about 10 minutes to provide greater detail on what the Clean Air Act does and how it came to be the principal vehicle for dealing with carbon dioxide emissions and climate policy in the United States. After Professor Cole talks, we'll then turn to Professor Almendares, who will talk about what this case means for changes in administrative law generally, both in terms of procedure and this new major questions doctrine that the Supreme Court enunciated, and how the court has provided some breadcrumbs that might lead us to understand how the court will build on this precedent. And then we'll turn back to Professor Cole briefly to talk a little bit about what might happen next within the EPA, which does need to think about what its next step will be in regulating carbon dioxide emissions from power plants that are burning fossil fuels. To our audience, please post your questions on the webinar question forum. There's a Q&A icon at the bottom of your screen, and I'll go through those questions. And after we've heard from our panelists, I will pose some of your questions for us to respond to. So Professor Cole, take it away on the Clean Air Act.
Thanks, Rob. So the history here is somewhat long and convoluted, and so I'm going to be simplifying it to a substantial extent. Nearly 20 years ago, environmental groups as well as some states petitioned EPA to make an endangerment finding under Title II of the Clean Air Act, the part of the Clean Air Act that regulates motor vehicle emissions. EPA wanted to regulate greenhouse gas emissions from motor vehicle tailpipes. The Bush administration denied that it had authority to make an endangerment finding for greenhouse gases because those gases, carbon dioxide and so forth, were not contemplated as pollutants when Congress enacted the Clean Air Act in 1970. They were taken to court by the petitioners. So in 2007, the Supreme Court ruled that EPA had a non-discretionary duty under the Clean Air Act to make a finding, either that greenhouse gas emissions endangered or did not endanger public health. The Supreme Court ruled that that EPA had to go back and make this endangerment finding one way or another. In 2009, Barack Obama's EPA made the endangerment finding, which then required it to regulate motor vehicle emissions of greenhouse gases. Having done that, Section 111 of the Clean Air Act allows EPA to regulate greenhouse gas emissions from stationary sources, which EPA did in a series of regulations. It started by regulating emissions at new and substantially modified stationary sources. And on judicial review, the Supreme Court upheld the motor vehicle emission standards and most of the regulations of new and substantially modified stationary sources. Then came the Clean Power Plan, which targeted greenhouse gas emissions from existing power plants. Traditionally, under the Clean Air Act, states have primary authority for regulating existing stationary sources within their boundaries. But this was not the first time EPA had directly regulated existing power plants, the most obvious example being in the acid rain program, part of the 1990 Clean Air Act amendments. In setting emission reduction targets under the Clean Power Plan, EPA sought to incentivize a switch from coal burning to natural gas and greater use of wind and solar power. And it was this fuel switching component that drew the ire of the Supreme Court's conservative majority. While the Clean Power Plan, as Rob mentioned, while it was before the DC Circuit on judicial review, the Supreme Court imposed a stay on implementation of the plan until judicial review was completed. And this was the first time that the Supreme Court ever stayed implementation of an EPA regulation before judicial review was completed. While the DC Circuit was still considering the Clean Power Plan, the Trump administration came into office and asked the court to hold off on reviewing the Clean Power Plan, which it intended to replace. However, it wasn't until 2019 that the Trump EPA formally repealed the Clean Power Plan, replacing it with its own rule known as ACE. Now, like all Trump administration environmental rules, the ACE rule was hardly regulatory at all and not very well supported by substantial evidence on the record, which is what the Administrative Procedures Act requires. The day before Joe Biden took office in January 2021, the DC Circuit completed its review of Trump's ACE rule, which the court vacated along with its embedded repeal of the Clean Power Plan. However, the DC Circuit did not expressly reinstate the Clean Power Plan. In fact, subsequent to this decision, at EPA's request, the DC Circuit stayed that part of its own judgment vacating the repeal of the Clean Power Plan, pending a new rulemaking by EPA. The Biden administration had no interest in resurrecting the Clean Power Plan for the reasons Rob mentioned, particularly the fact that its goals for 2030 had already been attained. despite the fact that the CPP had never been enforced. It was simply market processes that led to these emissions reductions, which gives some indication that the Clean Power Plan itself was not all that significant a rule to begin with. Bear in mind, throughout all of this, the Supreme Court never lifted its 2016 stay on implementation of the Clean Power Plan. And that's something the DC Circuit itself could not have done. So the Supreme Court then improvidently grants certiorari in the case, not to reconsider the decision about the ACE rule, which was the only rule up for review by the DC Circuit, but only to consider whether the Clean Power Plan, which was not at issue in the DC Circuit, violated the major question doctrine. So the Supreme Court takes up this question, and the ruling is what follows. It concluded that the Clean Power Plan, which had never been in effect against anyone, violated the major question doctrine, a doctrine that the Supreme Court had never before invoked in a ruling, saying that essentially when EPA speaks to a major new issue, an issue with big political consequences or big economic effects, so forth, Congress must give it express authority to do so. And it couldn't do it, it may be in the existing legislation, but in this case, it found it did not exist in the Clean Air Act as written. And so Congress would have to act before EPA could regulate fuel switching in effect. And this despite the fact that none of the parties who were petitioning the court for review had standing, which is a constitutional requirement. To get your case heard in court, you must have suffered some actual injury in fact. Either the injury must either be actual or imminent. But given the circumstances of the Clean Power Plant, where it had never been in effect and no one wanted to put it into effect, none of the parties suffered either actual or imminent injury. And Justice Roberts went to great lengths to obfuscate that issue. All right, so that's what the court decided and how this whole process came along. And so now I'll turn it over to Nick to talk about the effects with respect to administrative law.
Before we get to Nick, I just want to say that I've, through some side channels, heard that some people listening in were attempting to pose questions using the chat icon. The chat icon is disabled. If you have questions for us, please click the Q&A icon. Professor Almendares.
Thanks, and yeah, I look forward to hearing the questions. Already, for those of you who aren't already familiar, you get a taste for sort of how complex administrative law can be, right? We have lots of different areas of law kind of coming together all at once, ranging from standing doctrine to the more general Administrative Procedure Act and a bunch of doctrines like the Major Questions Doctrine, plus these very specific provisions of the Clean Air Act and how they all fit together, which is a whole other complexity. So yeah, this is fun. It falls to me, I think, to say some kind of very general words about what this doctrine seems to mean. And I think I want to focus on where it comes from, right? So briefly, and Professor Cole touched on this already, and as both he and Professor Fischman mentioned, we had an expectation that something major would happen in this case because the court had gone through a lot of effort to reach out and rule on this. So we had an expectation that something was coming. And so if you see news coverage or commentary on that, it's probably from within that frame. And what comes out of it is that this is really the first formal majority opinion that embraces what goes under the label the Major Questions Doctrine. And you can see a pretty strong preview of it in the OSHA vaccine mandate case, especially Gorsuch's concurrence to that case. You can summarize the Major Question Doctrine. We touched on this already, is that if it's a, quote, major question, then Congress has to, quote, speak clearly in order for the agency to have the power to regulate, to have the power that's claiming to have. I use a lot of quotes in there because those are phrases that we don't have a good sense of what they mean. What counts as a major question or major issue is up to the court, of course. Gorsuch's concurrence in this case, joined by Justice Alito, tries to add some definitions to this, but honestly, that ends up just being kind of a grab bag. According to the majority, it's something of economic or political significance. And that's kind of debatable in this case for many reasons, including kind of the mootness of the dispute. But as you can imagine, almost anything worth regulating is probably going to fall under the umbrella if a court thinks so. I want to talk about the legal basis for this doctrine, which is still, as you can gather, I think pretty ambiguous, the doctrine itself. I want to talk about the legal basis and kind of the political theory embedded in it, and maybe a few of the rhetorical arguments that are made in the majority opinion that are going to be going forward. So Roberts, writing for the majority, connects the major question doctrine to a line of cases. And I think this hides how radical a departure in doctrine it is. Kagan's dissent characterizes this line of cases as just doing ordinary statutory interpretation. That also doesn't quite feel right to me. These cases are quite idiosyncratic. And I'll be honest, I'm pretty disappointed by the court's reading of these cases. We do better work than that in all of our classes, because it's kind of pulls these isolated quotes and ideas out without a ton of discussion, or really any real discussion or consideration about how these cases could be distinguished, or how they would really fit in. So I would say major questions doctrine is something really new for us. Again, previewed in previous cases, we kind of saw that this might be coming, but this is not like some sort of long-standing thing. And just to give you a flavor of where these cases come from, I want to compare what I think is the leading case to draw something like the major questions doctrine from, which is Fda B Brandon Williamson, another statutory interpretation case from the 90s. And that had to deal with the regulation of tobacco and cigarettes, and nicotine in tobacco. And a plain reading of the statute at issue in Brandon Williamson gives the FDA complete power to regulate tobacco, which makes perfect sense. Nicotine and tobacco are drugs, and drugs in that statute is defined very broadly. Despite this clear text, though, the court found the FDA did not have the power to regulate tobacco. So you can see the connection to the case before us, right? It looks like EPA should have this power to regulate these emissions, but well, when you read this statute carefully, the court says no. But the linchpin of that case, I think, is what I would label a reductio ad absurdum argument. Okay, the court reads the statutes to require the FDA to ban tobacco, because tobacco has a lot of negative health effects, which is common knowledge now. And it also has no therapeutic benefit to counterbalance that. So if you compare it to like chemotherapy or immunosuppressants, those have a lot of negative health consequences too, but there's something on the other side of the scale that makes them valuable, makes them helpful to health. And the court said, we don't think that the United States Congress meant to accidentally or silently ban tobacco, right? Now, we'll just go with that reading for a minute, right? That's startlingly different. That's based on this sort of confluence of very specific statutory directives that would lead to this absurd result, accidentally banning all tobacco products. The major questions doctrine we have here in West Virginia v. EPA is basically a license to courts to evaluate whether something is a major question. And once then it requires this special statutory blessing from Congress, right? So I said, a radical, really substantial change from the doctrine that we all teach in our classes until very recently. So that's where we start with. There is, I think, an attractive, both rhetorically and maybe ideally, political theory behind the major questions doctrine. And this comes up a little bit in this case, and again, a lot in Gorsuch's concurrence in the vaccine mandate case, right? Which is that Congress, elected representatives, should be making the major decisions that affect our lives and the country as a whole. And I think there's something really appealing about that, but especially as it comes through in these cases, it's a pretty simplistic view of politics, more simplistic than we've seen in previous cases. Agencies like the EPA are democratically accountable. They're accountable to both the president and to Congress. And this is especially true in major cases. And you can see this sort of in the history that Professor Cole touched on, right? Trump's EPA did something different than Obama's EPA and Biden's EPA. And there's no real question in this case or in the vaccine mandate case that the agencies in these cases are following presidential priorities and directives, right? No one is confused about Biden's stance with respect to coal emissions as opposed to Trump's stance with respect to coal emissions, okay? And that's just the president, who is also democratically elected. But if Congress wants to stop the EPA from doing something, it can anytime it wants. It can amend or even repeal the Clean Air Act. It can amend or probably ban the existence of the EPA. It could certainly defund the EPA if it wanted to. And there's a bunch of other like non-statutory tools that it can to discipline an agency that's doing something it doesn't want. So while it might be nice, I think there might be some affection. I personally think it would be appealing if Congress took a more active hand in making major policy decisions. The major questions doctrine strikes me as a poor way of achieving that goal for a few reasons. First of all, if I'm the Congress who enacted the Clean Air Act, I might be forgiven for thinking that I did speak quite clearly. You know, I might, want to write a letter to the court that said, and this, of course, kind of ahistorical, but they create a detailed, comprehensive statute framed in broad terms, right? So again, when I started this off and tried to define the doctrine, I'd said speaks clearly. You should probably have, air quotes around it because we don't really know what that means. And what the major questions doctrine seems to set up is that when a court decides that's a major question, then it's up to the court to decide whether Congress has, quote, spoken clearly on it. And if not, say if that's what Congress really wants to do, it's going to go pass another law, somehow making its intentions clear, okay? And it's hard for Congress to pass laws, especially sweeping ones. And we do not, as a general rule, require Congress to do this sort of thing. No court, to my knowledge, has told Congress it needs to go back and reenact sweeping legislation, like, say, trying to come up with some examples, the authorization to use military force, which is what was the legal authorization for us to go to war in Iraq and Afghanistan, RICO, one of the most substantial federal criminal statutes of all time, or the tax code. This is a unique stance for administrative law. And the idea of the major questions doctrine returns power to Congress strikes me as, at best, a little bit of a misnomer. Because, of course, like I just said, Congress had the power to stop any of these agencies anytime it wanted to. But also, the major questions doctrine seems to mostly give the power to the courts, as they are going to be the ones to decide what counts as a major question. And also, they're the ones who are going to be able to decide whether Congress spoke clearly enough. So I can see this being a very frustrating world for agencies on one side, but also for Congress, right? Who just have to figure out how they can communicate their intentions to the court. And this is kind of in contrast to the way statutory ambiguity was treated in administrative law, kind of up until now, which implicates the Chevron doctrine, which is something I can talk about, any of us can talk about maybe during the Q&A if people are really interested in kind of going down that little bit of a rabbit hole. One last kind of side issue, the major questions doctrine, but I kind of want to flag it because it's a kind of argument that keeps on coming up, is what I'm going to call Robert's anti-novelty stance. There's, again, it strikes me as a very rhetorically powerful move by the Chief Justice to characterize what EPA is doing as they just newly discovered this authority. So they've had the law in the book for decades, but all of a sudden now they've just figured out that they can do this. And that rhetorical move should make us immediately suspicious, right? That this power was actually granted to them. Again, this is a simplistic way of looking at policymaking and one that kind of ignores the role that, say, things like democracy are playing in what these agencies are doing. First of all, and this is kind of obvious, but I think it's probably worth mentioning, new challenges may arise, right? That call for novel responses, and global warming and greenhouse gases probably fits in that category. And the whole reason to set up a comprehensive regulatory statute like the Clean Air Act is to set up a system, a loaded, if you read the case, that's a loaded term now, but a system that handles these issues as they arise without much intervention from politics, from Congress, right? And just by the same token, you'd want the agency to be able to adapt and develop even new ways of handling old problems. So that shouldn't be a shock. But the second reason is this notion sort of belies the process of regulation. Agencies have all sorts of priorities. Many of those are shaped and informed by politics, that is, by democracy, by democratic accountability. An agency might not choose to do something for years because presidents or legislators kind of don't want them to, right? And what this anti-novelty argument coming from Roberts does is it wants to infer serious legal consequences from all of that messy political stuff. And so this argument kind of keeps on coming back. So I want to take this opportunity to flag it as one that I think is just not particularly sound. So there you go. Those are all my polemical thoughts to start with. Look forward, I see there's some questions. So I'll look forward to hearing what you all have to say.
Okay, so now I'm just going to talk really very briefly about the impact of the case on climate regulation in particular. Obviously, the court's ruling makes it substantially harder for EPA to regulate greenhouse gases under the Clean Air Act. Not at all. I mean, there's obviously a lot that EPA can still do regulating greenhouse gases. The court did not overturn the endangerment finding in Massachusetts versus EPA from 2007, although there are ways of reading the majority opinion in which you could think, well, it overruled Massachusetts versus EPA in all but name. In fact, it didn't even mention the case by name. Only the dissent mentioned Mass versus EPA by name. But it definitely makes it harder for the EPA to deal with climate change in a substantial enough way to make a big difference in terms of the overall outlook for climate change and for climate harm in the United States. It certainly interferes with the Biden administration's short-term and long-term goals. As an interim goal, the Biden administration sought to have a carbon emissions-free power sector by 2035. That goal is plainly unreachable because of this decision. And so also probably is the longer run goal of achieving carbon neutrality throughout the entire economy by 2050. Now, depending on your view of the climate change issue, that can be a good thing if you think that climate change really isn't that significant an issue and we shouldn't be doing all that much to prevent it. But on the prevailing science, and according to most national opinion polls in the U.S., there's strong public support for doing a lot more than we are doing on the issue of climate change. It seems especially egregious limiting EPA's authority in this way in the form of an advisory opinion, right? Overruling a regulation that was not legitimately before the court for resolution for plaintiffs who had suffered no actual or imminent injury from the Clean Power Plan. This indicates a certain level of hostility among the court's conservative majority to climate change regulation and to environmental regulation more generally, and indeed potentially to the entire regulatory state, as Nick mentioned. Roberts suggested that EPA's approach to minimizing greenhouse gas emissions might be sensible, but being sensible isn't good enough, and he's right about that. The agency has to act only in compliance with its enabling legislation, and that in this case is the Clean Air Act, and the court rules that the Clean Air Act does not plainly give the agency the power to require fuel switching. So the agency now has to go seek explicit congressional authorization if it wants to do that. Now, climate legislation is a very good idea. There are lots of reasons why we should have specific climate legislation. It would provide much greater stability in policy across administrations. For the last, more than 25 years, maybe 30 years, Environmental protection in the United States has been done by a combination of executive orders of the presidents and EPA regulations. We've never had climate change. Well, we haven't had substantive climate change regulation in the US. We have had climate change regulation in the past, but it was mainly about setting up some kind of regulatory system way back in the late 1970s. So getting off of this swinging pendulum of executive orders, from Obama to Trump, now back to Biden, and who knows what the next Republican president would do. All of this inconsistency does not do the US any good when it comes to international climate negotiations. We're not a reliable partner because we don't have a consistent climate policy. We never have had a consistent climate policy that has lasted any more than 8 years at a time. So legislation would certainly give us greater credibility in climate negotiations. But of course, one of the reasons why I believe the court was so attracted to the major questions doctrine in the first place is that they know Congress is dysfunctional. It's always difficult, as Nick mentioned, to enact legislation in Congress, and intentionally so, and Roberts talks about that. But now it's nearly impossible because of the culture wars and gerrymandering and Senate cloture rules, all of which require a supermajority in the Senate now to get through most kinds of legislation. So how likely is it, given legislative dysfunction, that Congress can actually do what the court says needs to be done for EPA to have this authority to regulate? Well, Congress can sometimes act in response to a perceived crisis, right? Most recent example, of course, is the gun safety legislation that was just enacted in the wake of all kinds of shootings that happen every week. The latest example being in my hometown yesterday. And so Congress can act in a bipartisan way on occasion. Can it do it for climate change? Well, as much as guns, environmental protection has become part of the culture wars, and so it's going to be very difficult. But I think because of the gun safety legislation, we cannot conclude that it's impossible. And there's special hope for something like a carbon tax, which would avoid Senate cloture rules. As a budget reconciliation member, it would only need a majority vote to pass the Senate. On the other hand, the 3-letter word tax remains a 4-letter word in Congress, and it's very difficult ever to create a new tax. The one possibility for a carbon tax would be that it could be used, it could be implemented in a revenue neutral way. That is by reducing income taxes, for example. We could reduce income taxes to the extent of a carbon tax. And so the government wouldn't be getting any more money from us. It would be taxing something that's bad, pollution, rather than something that's good, income. And even Republicans should like that, right? And yet, so far, we have not seen any movement in a good direction. So there's certainly nothing about this ruling from the court. It's a very, very much an activist ruling. And very much in an anti-regulatory direction. So it's no surprise that it's going to make climate change policy much more difficult to design and implement.
So that really helps us understand where we might go in terms of climate policy. And Professor Cole left off with what might be a useful legislative approach. We've got some questions that are oriented toward constitutional and administrative law that I want to pose to Professor Almendares. But I do want to follow up with Professor Cole for a minute, because the most likely next chapter in US climate change regulation will not be legislation. The Biden administration has promised that it will, in 2023, issue new regulations governing fossil fuel emissions from power plants. And so just back to you, Dan Cole, clearly after West Virginia versus EPA, the EPA cannot require fuel switching. What can the EPA do, and what do you think would be the best approach for the EPA to take in revising the standards for carbon dioxide emissions from existing fossil fuel power plants?
Well, that depends a great deal on what comes next out of the Supreme Court, because we don't know if they've settled on this or on the major questions doctrine, and they're content with it, and they're not going to be looking to increase its effect, or at some point they just start saying anything new that the EPA does is a major question. In which case, and saying, to the extent the Clean Air Act authorized EPA to do things in the past, it's already done all those things. So anything new it does may require new authorization. We don't know if the court's going to go there or not, but it's entirely possible. Generally speaking, under the Clean Air Act, EPA still has clear authority to regulate emissions. Now, one sort of a misnomer is that EPA was directly requiring fuel switching in the Clean Power Plan, and it wasn't. It was merely setting emissions limitations that would have required fuel switching, right? In order for,
or even you could say limitations that would have allowed for fuel switching as a way to find a lowest cost approach for any particular power plant.
Yeah, and I think if that had been more clear, maybe it would have passed muster, right? But I think if you look at the Clean Power Plan itself, it is trying to force fuel switching, right? It is trying to force it with the emissions limitations set there, and I think it's that sort of to use an old phrase from the Clean Air Act, technology forcing aspect that got the court's ire up in this case. But it's, again, nothing's clear because there's so much ambiguity in the major question doctrine, as Nick mentioned, that we don't know the extent to which anything the EPA does will or will not meet the requirements of the major questions doctrine.
Okay, well, let's talk a little bit more about the major questions doctrine. Let me turn to Professor Almendares. We've got two very good questions about two doctrines that law students encounter in the course of studying statutes and administrative law. And let me ask you to try to clarify the relationship between this new major questions doctrine and two existing doctrines of anti-delegation and Chevron interpretation.
Yeah, I'll do my best. So briefly, the non-delegation doctrine states that there are certain things that Congress cannot delegate to an agency, someone else. And this is an old doctrine. It's sort of like at the dawn of the modern administrative state. And the way it got cashed out was that Congress had to provide a quote, intelligible principle, marching orders, tell the agency what to do, right? And you can see the natural affinity for the major questions doctrine, which is sort of saying, you, Congress, have to set this. Now, formally, we generally think of the non-delegation doctrine as kind of being either dead or not placing very strong requirements. But the way I read the doctrine is there are vestiges of it. There's vestiges of this idea through kind of that pop up periodically throughout administrative law. And it's the same normative vision. This kind of relates to what I think is the political theory or the political economy behind the major questions doctrine. And I see it being very similar to the non-delegation doctrine, which is that the people, the institutions making major policy decisions, or any policy decision worth making really, should be democratically accountable, right? And again, I think that's like kind of an attractive theory. Major questions doctrine doesn't, I think, really get you there, because it's really the courts, federal courts doing it, incredibly not democratically accountable, versus what are modern agencies, and modern agencies tend to be actually quite democratically accountable, pretty democratically accountable. There's some important exceptions to that, like the Fed would be an exception to that, but EPA is not one of them. EPA is quite democratically accountable. OSHA is quite democratically accountable. So, but I definitely think that you can draw a pretty straight line from at least the theory undergirding non-delegation doctrine, especially when it's more recent, i.e. not 1920s, 1930s, incarnation, to the major questions doctrine. Okay, and interestingly, the court didn't really spell that out. They make one kind of gesture to a case, which is a really complicated case that I'm not going to get into, but it's a concurrence, that evokes the non-delegation doctrine. That's kind of it, right? So they could have really shored that up more, but instead they went a different route in their justifications. And the other question is about Chevron, right?
Yes, although let me just add, before we leave the non-delegation doctrine, that I read the concurrence by Justice Gorsuch, joined by Justice Alito, as flying a flag, indicating that to them, the major questions doctrine is a way to address concerns about Congress and agencies skating too close to that anti-delegation principle. Yeah. And I think it indicates we will hear more from at least those justices in terms of future cases where they'll seek to apply the major questions doctrine in a way that, instead of just limiting agencies, may actually limit how much power the courts will decide to let Congress delegate to agencies. But yes, could you talk a little bit about the relationship between this major questions doctrine and the great Chevron doctrine from the 1980s?
Yeah, and I have to confine myself to a very sort of straightforward understanding of Chevron, because Chevron, of course, has all these sorts of fiddly bits and details and subtleties, which, if you take administrative law with any one of us, you will spend entirely too long considering. But at its heart, Chevron, and it's kind of noteworthy, Chevron is also justified in terms of democracy, right? And you can think of Chevron as a decision to say the statute is ambiguous. So it's not quite clear whether the agency can do this thing or not. Whose reading of the statute should control? And Chevron says when it's ambiguous, the agency's reading of the statute controls, assuming that reading is reasonable, right? So assuming it's a reasonable reading, it's not outlandish. The court is supposed to say something to the effect that might not have been the reading I would have personally come to, but it's a reasonable reading, so we're going to go with your reading. That's Chevron in a tiny nutshell, right? And like I said, it's justified in terms of democracy in part, which is to say, on the one hand, Congress left this ambiguity. They knew what they were doing. We should defer to that decision, but also agencies are generally accountable to the president. The president's an elected person. We, the courts, are not elected. So, let the people's representatives have as much say in this as possible. That's, like I said, Chevron in a tiny nutshell. And Brandon Williamson, the case that I think is sort of most connected to this one, is also a Chevron case. And interestingly, the court says nothing about Chevron. It comes up in the dissent, which is shocking. So, and this harkens back to something Professor Cole said a little while ago, we don't quite know what this all means, right? It would be perfectly reasonable to read the major questions doctrine as a complete 180, right? Complete rejection of Chevron, at least in these cases, right? If there's ambiguity, that means Congress hasn't spoken, quote, clearly on it. And rather than saying, okay, agency, defer to you, and as you can imagine, agencies tend to say, we have all the power we could possibly want. Instead, the court's gonna say, no, go back to Congress, right? You don't have that power. That seems to be completely at odds with Chevron. But, and it's sort of funny because this is a case about do lawmakers intend to do things when they don't say it super clearly? the court doesn't tell us Chevron is henceforth overruled, or Chevron is henceforth overruled in major question cases, or in major question doctrine cases, they're an exception to Chevron. And these are interestingly court opinions that cite a bunch of law reviews, right? Anyone who's spending time with law reviews knows what the Chevron doctrine is and knows what we label it. We label exceptions to it. We label different steps to it. We do all this stuff. No mention whatsoever. So you could read this as the beginning of the end of Chevron. That's a perfectly plausible reading.
I think it's fair to say that the EPA was acting under this authority in the Clean Air Act that says that the EPA must set procedures for states to set standards of performance for existing sources for any air pollutant using best systems of emissions reduction. That is just the sort of broad language that doesn't precisely address the narrow issue of how to interpret the statute with respect to carbon dioxide emissions that the Clean Power Plan would have passed under the Chevron test. This court has announced that the Clean Power Plan does not pass the more stringent test requiring that Congress clearly speak to the issue at hand under the Major Questions Doctrine. So from that perspective, I agree with Professor Almendares that the Major Questions Doctrine does the work of, in this case, carving out a new exception from the Chevron doctrine. The Chevron doctrine is disliked by many libertarians because it does empower agencies to fill in the gaps, to clarify the ambiguities of the statutes where Congress left those open. The Major Questions Doctrine allows for the domain of Chevron to be shrunk. So rather than having to overrule another precedent, and I think the court might be sensitive to the politics of it being this kind of out of control activist body that's going around overruling all these precedents it doesn't like. West Virginia versus EPA is a very different approach from Dobbs. Dobbs says we're stare decisis doesn't count here because there aren't property or contract interests. The court could have done that in this case with respect to Chevron, but the approach here is just ignore Chevron, develop a new doctrine that covers this sort of situation, that provides for a much narrower passage for what the agency has to navigate in terms of making sense of a broadly worded, ambiguous statute. I wasn't sure, Professor Cole, if you had a comment on that or if we should go on to another question.
I think we should just move on and maybe get some questions from the attendees.
Okay, well, another question concerns, it's a Dan Cole question, which is let's say the EPA does want to continue to proceed with regulating greenhouse gases under Section 111D. What more could it do? And just to add a little bit more detail to the question, I mean, could it or should it devise a different set of rules for carbon dioxide emissions, or should it instead turn to other provisions of the Clean Air Act and just say regulate particulate matter and ozone more stringently, which might indirectly accomplish the same sort of fuel switching away from coal that regulating carbon dioxide would be? That is, burning coal is a kind of inefficient way of creating electricity from the perspective that emits a lot more carbon dioxide than other forms of electrical generation, but it also emits a lot more sulfur pollution and particulate matter and ozone, which are regulated under a different part of the Clean Air Act. What would you think of that approach if you were advising the EPA today?
Yeah, so that approach makes some sense, but it also has its own difficulties, and that I imagine could upset the court. One thing that, for example, that there's some that conservatives don't like, and there's some sense that the court might go in this direction as well. So they don't like the use of co-benefits in cost-benefit analyses of regulations. So, when EPA passes a new regulation, a more stringent regulation, say of particulate matter, it has to create a regulatory impact assessment in order to justify it, to get it, through review by the Office of Management and Budget, and to, in some cases, to pass judicial review. Right? If the costs exceed the gains, courts are more likely to overturn the regulation. So if the direct benefits of regulating more particulate matter are fairly low, and the lion's share of the benefits, at least in the CBA, come from reducing greenhouse gas emissions, the court will be at least suspicious of that. Now, co-benefits, in a way, is a bit, from a realistic point of view, from an economics point of view, co-benefits is a complete misnomer. Another word for a co-benefit is benefit, right? And a benefit's a benefit. And we shouldn't, scrutinize whether or not the regulation is directly about a certain benefit or some other.
Kind of like cohabitation.
Yes, cohabitation is habitation, correct. Yeah, so so there are risks involved in going that way, as well as limitations on whether there's a scientific justification for more stringent regulation, whether the science would support greater regulation of particulate matter or ozone or whatever.
Okay, we've got just a couple of more minutes. I will try to just briefly address one more question that takes us back to something I mentioned in the introduction that we didn't get to talk about very much. And I think we steered clear of it because it's a pretty thorny area of the law, and that is standing. We had a question of whether the court actually addressed the question of whether these particular plaintiffs had standing to bring these issues before the Supreme Court. And my reading of the majority opinion is it does not really address the difficult standing issue. Justice Roberts does say something about standing. He says the Clean Power Plant rule set procedures for states. That is what the provision of the Clean Air Act does. The EPA is not directly regulating the power plants. It's telling states how they should, through state implementation plans, regulate power plants. And that's about as far as the majority opinion goes in addressing the standing issue. Turnabout is fair play. In Massachusetts versus EPA, the landmark 2007 decision, which the court found that the EPA had to interpret any air pollutant to include greenhouse gas pollutants if those pollutants can be found to endanger public health, was pretty liberal in finding that a state has a special stake in its interest in the environment and in what it has to do in terms of regulating its own pollution sources under the Clean Air Act. But the more difficult problem for standing in this case was the aspects of standing that require that plaintiffs bringing an issue before a court can show that their individualized injuries are fairly traceable to what it is the agency is doing, and that the court, through an injunction, can redress those injuries. And I think the majority opinion just steers clear because it's hard to know what to say. As Professor Cole mentioned, the Clean Power Plant never took effect, and it will never take effect because the goals of reducing the carbon dioxide emissions were already met just due to market forces. So that does suggest that whatever injuries the states like West Virginia and Indiana were purporting, and certainly that a coal mining company would have, their injuries were maybe not fairly traceable to the regulation. They maybe were fairly traceable to other things like the rise of fracking, which reduced the cost of natural gas, the favorable taxes and subsidies that promoted the generation of more fossil gas. And the court doesn't address that. What the court says instead is, well, the federal government here doesn't really ask us to address standing. This is a mootness issue, and the court explains why it should not moot the case under the mootness doctrine, which is really more of a prudential doctrine and less of a hardcore constitutional separation of powers doctrine than the fairly traceable and redressable elements of standing. So I think the court here is being pretty activist, both in reaching out to reach the merits of a case where these plaintiffs' injuries were not fairly traceable to a regulation that never existed and never would exist, so that the court can do, in a sense, another activist thing, which is create an exception to the Chevron doctrine and take away from the executive branch and arrogate to itself the decision of interpreting what an ambiguous provision in a statute allows the EPA to do. So with that, I'm going to call the webinar to a close. I want to thank Professor Almendares and Professor Cole for joining me today in the discussion of West Virginia versus EPA. Thank you all who participated in the webinar. I very much appreciate your interest. For those of you who are students, I look forward to more conversations when you return to Canvas next month. See you all then.